Okay, so thank you everyone for joining us today. My name is Kelly Chan. I'm the Community Relations and Public Service Manager here at CEB, which stands for Continuing Education of the Bar. We are a self-sustaining nonprofit program of the University of California. In today's webinar, we're going to hear from Louis Hudnell on strategies for starting your own litigation practice and getting your first case, handling large and complex matters, and growing your practice. I just wanted to know, a little housekeeping is, if you have any questions throughout the program, please chat them in. There is a chat button below your Zoom, and we'll go through the questions as they come in, but we'll also have about 15 minutes or so at the end to answer any other questions that you might have. So Louis here with me today, and he is an intellectual property attorney specializing in patent litigation and has a very successful practice. Louis, to start us out, why don't you tell us a little bit more about your practice and how you got started?
Yeah, sure. Thanks, Kelly, and thanks, CEB, for putting on this event, and thanks for all those in attendance today. I practice intellectual property, and primarily I focus on patent litigation, and I've been doing that my entire legal career. And I've been practicing for about 20 years, both in here in California, and then also a large chunk of time in New York City. And I worked at before I started my own practice, I worked at 3 large law firms. One here in California, and then 2 in New York, and I started my own practice about 10 years ago in 2010. And, that was, starting my own practice was not something I ever envisioned that I would do. It kind of just happened. Back in 2009, I was working at a firm in New York, and, that was during the, I guess the last recession, and excuse me. That was during the last recession, and one of the things that large law firms were struggling with at that time was developing new business, because there was a lot of competitors in the marketplace. People were outbidding large firms for cases. Coming in with very low bids for litigation work. And, one of the things that my firm realized that they needed to do was they kind of needed to come up with a strategy for addressing this new marketplace that we were in at the time. And one of the things that the firm did was they appointed business development leads in each office to sort of try to figure out, well, how do we navigate this new market? How do we make our services more valuable to our clients? And I was appointed the lead for the office that I was in New York, and I spent a lot of time researching other firms and other business models for law firms, because I wanted to understand, how firms were marketing themselves and delivering value and still getting clients in that climate, in that market climate. And it was as a result of that I kind of started to formulate the initial thoughts of how about how to break off and sort of start my own firm. And I just remember when I was working at large law firms, I would be there late hours at night or on the weekend, and I would just stare around and no one would be there. And I was wondering why is the firm paying for all this office space and no one's here? And there are many other practices that you'll find in the big law firm model that really just don't make sense. We're going to talk about those a little bit in a minute, but it was kind of this process of realizing some of the inefficiencies with the big law firm model, studying the other types of models that were in the marketplace back 10 years ago, that kind of launched me into starting my own firm. And so when I started my firm, I presented myself as a modern intellectual property firm with a focus on patent litigation. And the modern sort of in that statement was a reference to stripping away all of the inefficient practices that are built into the big law firm model. I wanted to, create a new model that was designed to, deliver better value without all of the, things like hourly billing and expensive office space and, expensive leases in large major metropolitan areas. All these things I kind of wanted to strip away so that I could, basically, try to build a better model for a law firm. And so it was kind of out of that process that Hudnell Law Group was born. We offer big law firm expertise with small firm value. And what that means is, the pillars that are sort of the foundation or kind of the base of my practice are one, providing experienced attorneys, two, offering a wide variety of fee arrangements or alternative price arrangements for my clients, and three, what I call alternative resourcing, which is essentially strategically plugging in different pieces into each matter as needed. And I'll kind of get into that a little bit on a later slide. But really, the common kind of the foundation of my firm was to, like I said, deliver better value to clients, align my interests with my clients. Hourly billing inherently is not in the client's interest, even though many clients still prefer hourly billing today. But obviously, the more you bill, the more the client spends, the better it is for the firm. The least benefit, it's not as good for the clients if hourly billing is too much. And also, I wanted to, make the price of my services commiserate with the value that I deliver for my clients. And what that means is, when you have clients who don't want to pay your rates, that doesn't necessarily mean that your rate is too high, your hourly rate is too high. That just may mean that they don't feel that they're getting the right value for the price that you're charging. And so one of the things that sort of I sort of the foundations of when I started my practice was trying to bring that, closer together so that clients really felt that they were getting essentially the most bang for their buck. So 10 years ago, like I said, I took the leap and started my own practice. And one of the things that I always get asked when about how I started my practice was, how did you do it? What did you do, sort of right out the gate? How were you able to sustain yourself? And I tell everyone who's come to me, who's been thinking about starting their own practice or who's just started their own practice, I always tell them, at a minimum, you have to have a runway of about 6 months. And what I mean by that is you have to have about, enough capital or savings to get you through about 6 months at the bare minimum. I mean, maybe for some people that may be, a little bit too tight. Some people that they don't need 6 months, but generally speaking, I think 6 months is the runway you need to sort of get your practice up and running so that you start developing new matters so that you can, move the practice forward. So there's a couple of ways that you can create that runway. One, you can just have personal savings. If you're thinking about, leaving a large law firm and you've built up savings over time, and you want to go off and jump into the small solo ring, you can rely on your savings to sort of get you through. The second way that and the way that I actually was able to launch my practice was to have clients that carried over from you from your previous firm. Now, in my situation, as I said earlier, I'm a patent litigator, but none of the clients that I started my practice with were litigation clients. And so I ended up having to do what we call in the patent world patent application work to sort of carry me for those 6 months. And in my case, it actually turned out to be 10 months before I got my first litigation. But I needed those clients. I needed to sort of expand the services that I was willing to offer, willing to do, in order to get me through sort of the initial phases of getting my firm off the ground. Another strategy that people use to start their own practice is they leave a large firm with a group, and they leave with a group that has some work that they can immediately jump right into in terms of cases that litigations that they're working on that they can carry over and start the new practice. But again, I come back to that 6-month number. Even if you have let's say a few litigations or litigation client, if that litigation work is not going to last you 6 months, then you're going to have some other sources, savings, or some other types of clients to kind of get you through that initial phase. So that's always the advice that I give people who are thinking about entering the ring and starting their own practices. Figure out what your runway is and how long that can last for you. The second thing that I think is critical if you're thinking about starting your own practice is having a plan. I call it an action plan. I know some people may call it a business plan, but I like to think in terms of what actionable steps can I take to advance the practice, as opposed to the business plan, which I always feel like I get bogged down when I'm trying to create a business plan, because I never really know what I think the business is going to look like, but I know what steps I need to take. So that's why I focus on writing an action plan. But definitely have some plan in place for how you're going to set up your practice in terms of the fees that you charge, your cost structure. We're going to kind of get into that on the next slide. The types of clients that you want to attract. All those things I would reduce down to a plan of action, so that you have, when you enter the ring, so that you have something that you can take action on as you move your practice forward. The final piece of advice that I give to people who are looking to start their own practice is to tell everyone that you're starting your own practice. And it sounds very simple, but really, when I took the leap, when I left Big Law, just the act of just reaching out and sending an email blast or reconnecting with folks, it generated so many conversations with people who were interested to hear what I was doing, how I was going to do it, and opportunities came out of that. All those conversations, in one way or another, led to something that helped move the ball forward. And people, I find what I really didn't expect when I made the jump was like how willing people were to help. And so by just telling everybody that you're out here, I've got my own shop now, or I've created this practice with this partner, that announcement is so critical, and following up on all the conversations that build off of that was really critical to sort of getting the ball rolling and getting new matters and new opportunities coming in the door. So as I kind of touched on earlier, when I started my practice, what led to my practice was giving a lot of thought to the type of business model that I wanted my practice to have. And when you're running your own firm, there's basically two things that factor into your business model. That's the price that you charge for your services and the costs that you incur to deliver those services. And because I'd done a lot of studying of other firm models, and I wanted to kind of build, as I said earlier, I wanted to kind of build this model as a more efficient, better value service model for my clients. I really focus a lot of attention on developing a flexible cost structure for my firm. And what that means is I sort of eschew any, sort of eschew all the large fixed costs that big law firms have. So salaries, expensive leases, expensive, other things that are, expensive overhead. I try to focus for every single thing that I add to my practice. I try to make sure that item is an item that's a variable cost that I can either implement when I need it and take it away when I don't. The reason for that is sort of a concept. Is the reason for that? The conceptual reason for that is the difference between a big law firm model and the model that I have. Big law firms are set up to do cost-first pricing. What cost-first pricing is that big law firms incur certain expenses, salaries, leases, overhead, office equipment, furniture, all these things. Then they determine, once they have that number, then they figure out how much profit then they want to make. Then they figure out their price. Generally speaking, that's how it works. My model is the opposite of that. I employ price first costing, excuse me. What price first costing is that, I go out, I meet with a client, I determine what their budget is, what they can spend on a particular matter, what they're willing to spend. Once I have that number, then I determine whether I can deliver the value or the services that they want, whether I can employ the cost that I need to deliver the value for service that they want for the number that they're able to pay. And if I can, then I'll take them on as a client. And if I can't, I won't. And so, because I have this, flexible cost structure, because I don't have all these fixed costs that I'm wedded to, on a monthly or an annual basis, I'm able to do that. I'm able to be flexible and adjust my pricing to the needs of my client. And again, it comes back to the point that I was addressing earlier. My goal when I started out was to offer flexible pricing so that my pricing was commensurate with the value that I was delivering for my clients. And by having the flexible cost structure that I do, I'm able to offer clients flexible pricing. And, this is still at the core of my my firm today, the core of my model today. Although, like I said, some clients just simply prefer to bill by the hour, and I have clients that bill by the hour, and that's just, it's easy, they understand it. And so, that's what I offer. But for the clients that don't want to pay by the hour and want some alternative type of arrangement, the way that I've structured my firm allows me to offer many different types of pricing for my services. And I feel that allows me to take on matters that I wouldn't necessarily be able to take on if I were at a large law firm. So the next thing that you need to think about in terms of building a practice is actually building the practice, getting business. And I'm not a business development expert, and I'm not, I could probably talk for a whole hour on business development, but I wanted to focus here on just some very specific things that I've in my experience, I've noted are different about business development when you're in the small law world as opposed to in the big law world. And the very first thing that comes to mind is you have to it really requires a change in mindset. When I was at large law firms doing litigation, you're primarily doing defense work. And what that entails is a client or a company gets sued. You find out about it. You send them a letter. to let them know you get sued and that you're interested in representing them on the case. You may do a pitch with them to try to get the case, and you're competing with 20, 30, 40 other firms for the same matter. And then they decide who they want to hire. Well, that what I've learned over time is that practice really doesn't suit small law firms. Sometimes it happens, but it's not all. I feel like I've realized it's not always the best strategy for developing business. And one of the best pieces of business development advice that I got very early on in my practice was that it takes about 3 years for someone to trust you with their litigation matter. 3 years. And just to give you some perspective, it takes about when I heard this, the person who told me, he said, just if you think about it, it takes about an elephant 3 years to give birth to a child. So you're talking about a significant amount of time before someone actually will trust you, to handle litigation for them. And so what that told me, very early on when I was, trying to develop businesses, one, don't expect to get business right away the first time that you meet somebody, because it's going to take time. But number two, because when you're first starting off and you need clients to kind of get your business running. The second thing it told me is that I needed to look back and see who I knew 3 years ago, because those were the people who I probably already built up enough trust with for them to want to hire me. And so that's what I did. I really, one of the first strategies I employed when I started my practice was redeveloping past relationships that I had built up while I was in the big law firm world. And this is so critical, and this is something I still practice today, always looking back and see who I know, who I can reconnect with on any level, not just necessarily looking for business, but just always keeping up past relationships, because like I said, this time cycle is, you never know when because it can be so long, up to 3 years, you never know when that person will be ready to hire you. And so by keeping those relationships, by keeping those relationships from the past, you put you in a better position today to develop or to get in business. The second strategy that I think is sort of a mindset shift from big law firm world to small law firm world is developing more business from your existing clients. And I found that in the big law firm world, there's so much focus on just bringing in the next matter. When someone gets sued, you want to represent them on this litigation, the next litigation. You're just constantly trying to develop new clients, but you don't really have that luxury when you're in the small law firm world. And so, when you have existing clients who you can expand your footprint with, that is I found a better investment of your business development time, is trying to, grow business out of existing clients rather than trying to always bring in new clients. And then lastly, the sort of the third mindset shift in business development when you move from big law to small law is developing relationships with other attorneys. When you're in the big law firm, your mind is set to think, hey, we can handle everything. We're a one-stop shop. There's no reason for me to call, my friend or my colleague at other, big law firm, B, to helping with business, because we're probably competing for the same types of clients. But once you shift and you move to the small law environment, having relationships with other attorneys is so critical to developing business. I would say, if I had to, break it down, I would say that most of the work that I get now is through referrals from other attorneys. And it may just be other attorneys who are the same practice area as I am, who are either looking to partner on a matter or co-counsel on a matter, or, it's just other folks who aren't able to handle patent litigation. Let's say they do patent application work, but their client gets into litigation and they don't have the skill set to handle litigation. it can come that way. So, really what I found, very early on was that, building relationships with other attorneys, other, small and solo attorneys was really, really critical to maintaining a steady pipeline of business. And other sources where you can, if you don't already have sort of a network of referral sources, one of the things to do if you're heading down this path is to look into attorney networks. There's networks out there that are specifically just set up for exchanging referrals. You'll have attorneys from all different practice areas being part of the network, and each of them will, if you get a corporate matter, you refer it out to a corporate attorney. If they get a litigation matter, they refer it to you. And so I would investigate, these types of networks to see if there's a right fit for you. But again, I encourage you to at least have something, some source where you're interacting with other attorneys in order to generate referrals for new business. Bar associations are also another example of fertile ground for attorney referrals. So earlier in this presentation, I mentioned the idea of alternative resources. So this is kind of where I sort of explain what that really means. And what it really comes down to is building a team and strategically building a team and employing resources when needed for a particular matter. I always get asked when people ask me about my practice, is it just you? And the answer to that question is yes and no. It's just me in the sense that currently I'm the only attorney that's part of Hudnell Law Group. But on every litigation matter that I work on, there's a team of people that are either supporting me or that I'm co-counsel with. And so, litigation is not something that, there are times where you can handle, most of the work by yourself, but invariably there's going to be points in the litigation where you need to bring other resources to the table. And so this alternative resourcing model that I have is really something that is very different from a large law firm. In large law firms, it's sort of a one-stop shop. They have partners, they have associates, they have litigation support, all under one roof. What I did when I set up my model is I looked outward from my firm to try to find these different pieces to bring them to particular matters so that I would have the same presence and same resources available to bring to the matter as a large law firm. So for example, at the partner level, I have numerous, I'll partner with other attorneys at other small firms as co-counsel. I've entered into special counsel arrangements with other firms where they need additional litigation support or patent litigation support, and they'll bring me on to a matter to either run it or to help their team. I have numerous local counsel engagements where I effectively just do local counsel duties, review pleadings and filings, attend hearings, etc. At the associate level, I've kind of used two different types of resources. First, for the first, I would say 6 or 7 years of my practice, I had a flex time attorney working for me. And what this was an attorney who I actually had, in each instance, it was always an attorney who I had previously worked with at one of my previous firms. They had left the firm. They were still looking to keep their foot in the law. And so they joined me on a flex time basis where when I had work that I couldn't, handle all by myself, I would bring them on and they would, and I would employ them to do the work. And this was, this worked out very well because I was already familiar with them from having worked with them before in other firms, but also it allowed me to, essentially have a bigger team. If you don't have those types of relationships with other attorneys, other more junior attorneys at your disposal, then contract attorneys are another way to fill that gap. And there's actually now a number of services out there where you can find experienced attorneys who are really just looking for part-time engagements, and you can find very, very good help through these services and plug them into your cases sort of as needed. One of the analogies that I use to describe my practice is more like an accordion, and a big law firm is like a piano, meaning that my practice shrinks, expands, or contracts depending on what's needed at any particular point in time. Whereas a big law firm, it's always a piano. You can't change it. You can't remove the keys. You can't remove the pedals. So they're always a fixed size, no matter if they're at capacity in terms of the work that they can handle or they're not. And one of the nice things about my practice is that when work on a particular matter or particular litigation doesn't necessitate 10 timekeepers or 10 people billing to that matter, there's only one person on the matter. And so again, it comes back to being able to deliver better value to the clients. And one of the ways that I do that is by keeping this flexible structure in terms of my human resources. Lastly, there are numerous litigation support services available in the marketplace. You can employ virtual paralegals, which I do, virtual assistants. There's vendors for handling all kinds of things, discovery vendors, doc review vendors, court filing vendors, vendors that will serve subpoenas. I mean, all these pieces are pieces that I use at my disposal to allow me to handle matters that a big law firm will handle all under one roof. The difference in my scenario is that I'm essentially sort of the air traffic control here. I have the matter, I'm kind of managing it, and then I look outside to sort of bring in the resources that I need to bear on any particular matter. Okay, so building the business. How do you get litigation work? It's not easy. I think Kelly asked at the beginning of the presentation how I got my first case, and to be quite honest, I was lucky. But I wasn't. But I was lucky, but I was in the right place at the right time. And again, this comes back to sort of maintaining past relationships. I got my first case through a referral from a law school classmate of mine, a good law school classmate of mine, who was working for a small company that was looking to, a small operating company that was looking to litigate or monetize its patent portfolio. And he put me in touch with the CEO. This was, almost 2011 timeframe. He put me in touch with the CEO. I made excuse to fly out to Los Angeles to meet him. We had a good meeting. He told me what his strategy was, and I was able to, out of that, get my first litigation. I mean, it was really sort of like, again, it comes back to being at the right place at the right time. But when you're starting your practice, you can't always rely on luck. And so, what I've learned over the 10 years that I've had my practice, there's some other strategies that you can employ to get litigation work. And if you recall earlier, I said when I started my practice, or my suggestion if you're thinking about starting your practice, is to have an action plan. And the first thing that I wrote down on my action plan when I started 10 years ago was that in order to get litigation work, you either need to be close to the courthouse, close to an active courthouse for your practice, or close to the clients that you want to represent in litigation, or both. Because what I noticed from my time in big law, it seemed that the offices or the attorneys in offices that were the busiest were the ones who were either close to an active courthouse for patent litigation or close to clients who were involved in patent litigation. And, I knew very early on that was something that was going to be critical for my practice. But when I started my practice, I started it in New York. I was in New York at the time. And I knew that in California, and particularly here in the Northern District of California, that I would have access to both. I would have access to an active courthouse for my practice and active clients for my practice. But I didn't want to move to California. But about 5 years in, about 2.5 years into my practice, I took on a partner. We had a practice together for about 1.5 years. Then we decided to split. And it was at that time, about 5 years in of being, outside of big law, that I just went back to that very first thing that I wrote down on my action plan. And I moved. I decided to make the move. So I moved to California, Northern California, 6 years ago in 2014, specifically because of this reason, because I knew that in order to continue to build and grow the practice, I need to be close to the active courthouse for it and close to clients. And, so far I'm still here. And so it seems to be working out. But I really feel like, not everyone can be in a position to move. Not everyone can have that flexibility, but you need to really focus on, okay, if I can't be close to the courthouse and I can't be close to the clients, how am I going to generate litigation work for myself? And if you're not coming up with any answers, then you have to at least give some consideration to making a move to be in a better position to get those type of matters. The second building the litigation business strategy that I employ is just simply finding clients that either like to litigate or that get sued. And one of the things that, I guess it's a practice that I started doing, when I was in big law, and I still do today pretty much every single morning, is I really, study the docket. I really study the dockets for my practice, for patent litigation. I get an alert. I get actually 2 alerts every morning that show me all the cases that are filed nationwide, patent litigations that are filed nationwide. And I just look at it just so that I have an understanding of what's going on in my practice area in terms of, what clients are out there, who's getting sued, who's litigating, who's getting sued, et cetera. And, that really is, I think that's really critical to having that understanding, because that helps you focus your business, development efforts. You want to have an understanding of a client's litigation history. You want to know, is this company likely to get sued? Are they likely to litigate at any point in time? How many litigations have they had in the past, 3 years, 5 years, 10 years, for whatever your practice area is? And if you and you need to, once you sort of get that general understanding, then you can figure out where you need to focus your time, or the types of people, and if you don't have, or the types of people that you either need to meet, or if you already know them, the types of people you need to focus your time and energy on in terms of trying to grow your business. It seems very simple, but it's comes back to sort of putting your focusing your attention on sort of the right things to get the business that you want. The other strategy that I employ in terms of generating litigation business is celebrating all wins. you know, when you're a litigator, your business is winning, and you're judged by the results that you're able to achieve for your clients. And so when you get those results, and you have something to talk about, and you have something to market, you want to tell people. You want to let them know that, hey, I'm capable of doing this. I'm capable of going to battle for you, and getting you a favorable result. And so, celebrate all wins means, when you have, even if it's, something simple, that happens in your client's favor, let people know about it. That becomes a marketing tool for you. And it's through that other people who are looking to hire litigators will notice, and then potentially consider you for handling their work. So keeping with kind of the punching theme, the boxing theme that I created for this presentation, one of the other, one of the strategies that I have for my practice is being flexible. And so I say, float. You have to be able to float like a butterfly. You need to be light on your feet. My practice today is in several respects, very different than the vision that I had, 10 years ago when I first started my practice. And the reason for that is because, you don't know, clients come at you from different directions. You don't know, when you're small, you have, clients coming at you from different directions, and you need to be able to be flexible to address, their needs and help them achieve their goals. And, by having a more of a flexible structure, I've been able to do that. And, every client's different. And so you have to be flexible. As I was talking earlier, you have to be able to be flexible with your rate or the price for your services, so that you can, attract a certain type of client or not attract a certain type of client. And if you just sort of, move forward, is kind of the mindset that, hey, I'm just only going to bill by the hour. That's what I'm going to do. It works. It's easy. It's simple. Well, when you're in the small law environment, that's going to take you out. It's going to take you out of some opportunities that could be available to you. So, for example, when I began my practice, I realized that I got a lot of calls from plaintiffs, and plaintiffs that wanted me to handle cases on contingency. And so, that was, being willing, even though at the time when I started my practice, I don't think I had done any contingency work at my previous firms. And even though I'd probably done, a couple of plaintiffs cases, but I realized that I needed to expand what I was willing to do as a litigator in order to get work, in order to get new matters. And so by considering contingency cases, and by being willing to work on both sides of the V, plaintiff versus defendant, that expands the pool of potential matters that you can take on in your practice. So you have to be willing to be flexible. Another thing that in terms of being flexible is taking on cases that are outside your lane. Like I said, I practice patent litigation, but primarily. But over time, I've handled some copyright cases that I felt that I was able to handle. I've worked on an antitrust case that had patent aspects to it, and so when those type of opportunities come at you, again, you have to be open-minded. You have to be flexible, and you have to say, is this something that I can that I feel I can credibly handle, or if I partner with another attorney, can we credibly handle this matter? Again, that will just give you more opportunities throughout the course of your practice. In terms of monitoring trends in your practice area, there's been two sort of major developments that have happened in the time that I've had my own practice, in the patent world. One is the introduction of the Patent Trial and Appeal Board, which is a administrative trial before judges at the Patent Office who determine the validity of a patent, that has been really a boon for many people's practice who've taken the time to really focus on that that forum and the types of matters that are handled there. I've over time developed some expertise in that area. I'm still primarily a litigator in federal district court. But I had to learn this new trend, because now now really you can't talk about a patent litigation these days without really talking about a potential for a trial on the patent in the Patent Trial and Appeal Board. The second major trend that occurred in the time that I've had my practice was a change or shift in the venue rules for where patent cases can be filed. And as it turned out, once the Supreme Court, quote unquote, changed the law in this area, or at least clarified the law in this area, more cases started moving out of the Eastern District of Texas, which at the time, 3-4 years ago, was the busiest jurisdiction for patent cases in the country, and has now moved a lot of that work to, luckily here, the Northern District of California, but other jurisdictions as well, District of Delaware, Central District of California. So by monitoring those trends in your practice area, you're able to figure out again where you can position your practice to get litigation work. And then finally, in terms of packing a powerful punch as a small firm, I like to say we like to sting like a bee. When you're up against large firms in litigation, when really in all litigation, people try to push you around, and so your job as a small or solo litigator is to not let them do that. And one of the ways that you do that is by having good cases. And so I always tell people, or I always advise, people talking to me about, having their own practices, really vet the merits of your case. You want to have good cases that you can either be on the offensive side, on the defensive side. Vet the case is very hard, because when you have good merits, it makes it, you pack a more powerful punch as a litigator. Now, granted, when you're in the small and solo world, you have a little bit more freedom to take on different types of cases, and maybe there's legal arguments that you would be willing to pursue, when you're in the small solo world, as opposed to when you're in the big law world. And so, I encourage people to consider, pushing the envelope a little bit, but use good judgment. And one of the ways that I've been able to sort of, make sure that I'm not, going too far, is by having a sounding board, having someone in your corner who you can bounce things off of. It'd be no different than, walking down the hall if you were at a big law firm and walking in someone else's office and just, hashing things out and getting their perspective on it. There's no reason that you can't do that when you're in the small solo world. And so you want to have those other attorneys. There's a handful of attorneys that I could just call at any time if I'm thinking about filing this motion or making this argument or litigating before this judge. I can just call and just talk to and just bounce thoughts off of. And I think that's critically important, particularly when you're in the small world, to kind of have that backbone. So that you have that punching power that you need when you're litigating against others, and particularly large firms. And then finally, always respect your opponents. I think I've learned that even more so being on the small and solo side, because again, as I mentioned earlier, attorney referrals are going to be one of your best sources of new business. And you may be locked in a litigation with one attorney one day, and then the next day, that attorney may need to call you up to refer something to you. You never know how that's going to play out. And so, never lose, respect for your opponents. Always maintain respect. Argue the merits and not against the person is my advice. So finally, just to sum up here, what I've discussed today: be open-minded. If you're looking to start your own practice or own small firm, be flexible, be willing to try new things, both in terms of how your firm is set up, your business model, the types of clients that you do work for, the types of matters that you handle, and be resourceful. There are plenty of resources out there that can help you, that you can plug into your firm, that you can use to fill voids, and so use them. So a couple of resources that I have found, putting aside the human resources, a couple of other resources I found extremely useful in the time that I've had my practice. The first is a book by Paul Dunn and Ron Baker called The Firm of the Future. Great book. I read this when I, very early on when I was already, a few months into my practice. And this sort of, reinforced kind of the thinking that I had about how to set up a sort of a flexible cost structure and how to employ price first costing in my practice. It covers a lot of different topics, and I think it was really a great eye opener for someone looking to build a sort of a new business model for a law firm. Second resource I would point people to is the ABA's Law Practice Division, which you can find at lawpractice.org. And in particular, it comes out 6 times a month. They're 6 times a year, so every 2 months. Their Law Practice magazine publication. It's a great resource. It's primarily articles from other small and solo attorneys, offering insight on a lot of different areas of practice, from technology to management to human resources to alternative fees. I read this magazine religiously, and I would certainly encourage any folks looking to build their own practice to look into Law Practice magazine. And then finally, my law practice management tool that I use is Clio, and Clio has an annual conference, the Clio Cloud Conference. This year is actually last year was in California and San Diego, and this year it's also in San Diego. It's a great conference, lot of like-minded folks in the small solo world, a lot of innovative discussions and techniques and strategies that you can use to infuse into your practice. So I highly recommend looking into either using Clio as your practice management tool or attending their conference. It was the first time I went was actually last year, and it's just a wealth of information. And I've been able to over the past 3 months since I attended the conference, to try to infuse what I've learned there into my practice. So I definitely recommend it. That is all I had prepared to say, but if there's any questions, I'd be happy to answer them.
Yeah, you can definitely chat them in. We have just a couple more minutes. So if you have any questions, feel free to chat them in. But Louis, you did mention early on that you use a lot of different litigation support, different vendors, and do you mind sharing like the virtual paralegals and virtual assistants resources that you use? Sure.
So it's funny that you asked, because I was just speaking with my paralegal the other day, and I told her I might mention the name of her company on this webinar. I use a company called Alliance Legal Services. They're based in Florida, and it's basically what it says, a virtual paralegal service. Another resource that I recently used, in fact, it came out of the the Clio Cloud Conference is I was introduced to a company called Law Clerk. And what Law Clerk is it's kind of like Upworks for attorneys. So there's attorneys that are very experienced attorneys that are part of Law Clerk. You can hire them all through the web for freelance assignments, long-term assignments. I tested the service out a couple months ago. I like it, so I plan to kind of use that more. But that's another one that I recently became aware of.
Awesome. If there are any other questions, feel free to chat them in. But if folks want to get in contact with you, or if they have any questions that they want to just email you directly about,
go. Sure. Here's my contact information. Lewis@hudnelllaw.com. 3 L's there. Don't leave the L out. One of the L's out, else it won't get to me. Anytime, be happy to speak with folks. You can call me, send me an email.
One question just came in.
Oh, sure.
Do you have any ideas or recommendations about virtual office spaces?
I do. So I currently use Regus. I've used, when I was in New York, I used a company called Servco. They had a couple different locations within New York. I think they have a couple of different locations around the country. But I like Regus because they're basically everywhere. I mean, you can go to any city in the United States, even overseas, and have access to a Regus office. I mean, they offer a what they call a World Gold Card. So if I go, like for example, I'm heading to the East Coast tomorrow, and if I needed to pop into an office on the East Coast, I can go, and I have access to an office, internet, phone, etc. So I recommend Regus, but I know there's a lot of other different service providers out there. But yeah, thank you.